Good afternoon, everybody. My name is Anand Krishnan. I lead privacy and public policy at DSCI. I'm very happy to introduce our next session on privacy compliance, on functions, automation, and process revitalization. We're a very distinguished panel of speakers to dissect this very relevant topic. I would like to call upon stage Mr. Loga Murugan, Head Global Privacy Office, TCS. Ms. Isabel Barbara, co-founder, data privacy specialist and data security specialist from Witness Wise BV. Mr. Partha Chakravarti, a distinguished privacy professional in the Indian community for several years, currently working in the independent consultant capacity. Finally, I'd like to call upon stage Mr. Lalit Kalra, partner EY, who would be moderating the discussion. Due to certain personal exigency, Aswati is unable to join us. Now I would like Lalit to take the conversation forward. Thank you. My apologies. Lalit is facing certain technical difficulties. To take the conversation forward, I would request the speakers to introduce themselves and the organization, starting with Mr. Loga.
Thanks, Anand. Good afternoon, good morning, everyone. I'm the head of Global Privacy Office from Tata Consultancy Services. It's great to be on this forum and meet you all, though in virtual world. Thank you.
Isabel?
Hi, everybody, and thanks for inviting me here. It's really an honor to be here and share my knowledge with you. I'm a data privacy and security specialist, co-founder of BusinessWise, a small consultancy based in the Netherlands. We are hired for different projects in the public and private sector. I must say the last year we work especially for the Dutch government.
Partha?
Good morning, good afternoon, everyone. My name is Partha, and I've been working in this data privacy space for close to about 12 plus years now. So great to be in this particular session, and thanks a lot, Anand, for having me, and thanks DSCI. I look forward to interacting with all of you, and I think it's an opportunity to really not just exchange views, but also to learn. So looking forward to it.
Lalit, over to you.
Thank you, Anand. I'm sorry for the technical glitch. So it's a pleasure to be on this stage for AISS and discussing my views with the esteemed panelists that we have. So Anand has already introduced the topic on privacy compliance, intelligence, automation, and revitalization. So it's been 3.5 years, almost 3.5 years since GDPR came into effect. And in those almost 3.5 years, we've seen governments take significant steps toward enhancing privacy in their respective geographies. We've seen China coming up with a new law. We've seen South Africa UAE coming with a privacy law. India, we also have a PDPP which is about to get tabled in the parliament, and the governments are doing their bits in terms of enhancing their privacy. We've also seen industry taking significant steps in maturing their privacy programs. And as we speak, in the experience that we've had with working with large MNCs and the mid level companies, also, privacy is no longer a check in the box activity. It's slowly becoming a boardroom agenda, and it is on the way of a scenario wherein it would be standing along with the security that we see today. But there are significant improvements that we require for that to be taken towards. And in the last 1.5 year that we've been through in the entire pandemic situation, we've seen businesses struggle to keep themselves alive. We've seen organizations getting hacked on a regular basis. And in all these scenarios, we've seen privacy taking a backstage. We've seen some uproar in terms of organizations collecting vaccination data of the employees, health data getting compromised in multiple hospitals, and therefore emphasizing the need for keeping privacy back along with security and back on the table. So with this, I'll go ahead with my first question to Mr. Loga. So we've seen over an year of the pandemic for the entire remote working. How do you think have organizations refreshed their privacy program, and what are the key lessons that have been learned which organizations should implement?
Thanks, Lalit, for this question. Of course, none of us can forget the uh, difficulties unleashed by this pandemic, and of course, it also forced us many of the organizations to revisit and rethink on what was called the new normal, which is almost becoming the normal. Just taking a wider view, not only about privacy, but basically it started with the question which data is getting accessed and where is it getting accessed, and in that, how do we ensure that the data and privacy are safeguarded? That's the primary question that was asked. And in fact, thanks to our info security team, multiple modes and models of connectivity were brought up, considering the maturity of the technological maturity on the client's infrastructure environment. And we discussed openly with all the risks that are there in each of these models, and whatever was selected, we applied it immediately. So that is the first question that needed to be asked: what is getting accessed where, and how is it getting accessed? And the second thing is, it is not merely about the IT alone, but then every function, HR, admin, and say for example internal infrastructure team, we collaborated with them to understand what are all the typical things. We actually came out with a rapid response guidelines, which outlined what are the things that can be done and cannot be done at a very generic level, and then customized it to suit the local regulations and the directions and the guidelines from the privacy authorities, or even considering the local laws, especially the labor laws and all those things. So we ensured that while there is a global outlook what can be and cannot be done, it also needs to cater to the individual country, what is allowed and what is not allowed. Say for example, in one country, the government mandated that the proximity should be tracked, whereas it was not allowed in many countries. So we had to how do I say, customize or tailor the approach to each of these countries. Close collaboration was established, and of course, all our collaboration channels ensured that we could easily work together wherever, irrespective of where we are. And while we looked at, evaluated the policy, privacy policy, the response plan, and all those things, we also looked at what are the procedures that may need to be amended. Say for example, throughout the supply chain, even the service providers that we employ, how do we ensure that the privacy and security is taken care of. And of course, all these processes and technologies, the other important stakeholder is people. So close collaboration, engagement with them, underscoring the confidentiality and the privacy aspects of the data that they are handling. Many frequent touch points we did. That was one major change. And of course, non-work related topics like learn yoga, dance, not yoga, I mean, sorry, photography, and even coffee chats were organized to ensure that the associates do the have the sense of belonging, and also are kept aware and abreast on what are the things that were done. So
Yeah.
close collaboration with associates, having a global outlook, but still having a pre-authorized processes, what can be collected, what cannot be collected. That tight integration with every geography was key, Lalit.
Absolutely, Mr. Lower. That's very valuable input. So, starting covering entire people, process, and technology, and also ensuring that the local flavor comes in. So, this is where I would want to bring in Isabel. Isabel, I know if we look at it from a global perspective, there are policies, procedures that organizations bring in, but the on ground reality sometimes is different from what we see outside of the world. So how is that in the local markets? How did people adopt their privacy programs in the pandemic?
Yeah, and that will bring us to the question of how the challenges that we can find there, and there are quite a lot. And I cannot prepare myself knowing that this question will be coming, so I have like 10 points. I would like to mention number 1 and number 10 are really related for me personally, for what I have seen from my perspective, that I see different clients and industries in my daily practice. Um, Starting with knowing what you have. So I would say for me, something really important is what type of data do you have. That's something that I see a lot of companies still struggling with. Of course, we can like summarize with kind of data discovery, data classification is a step forward and more complex. But indeed, if you don't really know what you have and where you have it, you really cannot answer the rest of the questions that are necessary to comply with privacy. So that would be my number 1 point where I see that companies are still struggling with. And number 2, the in general compliance process at organizational level. In the GDPR, we have Article 30, where we are requested to have a summary of our processing activities. So as you will see, it's everything a holistic process. So if you don't really have an overview what the data you have, where you have it, you really cannot implement eventually at organizational level any compliance process.
Yeah.
And another point, number 3, and they are not in order of priority or anything like that. So it's keep that in mind. But another is awareness. So a proper awareness program, something that I also see very often. It's just a training every now and then because you feel like you are obliged to do something like that. But eventually it has to be a mindset. So I think from my perspective, it's as organization, you want to grow in maturity level, and you are really serious about privacy, and you really want to do a holistic implementation. Then you also need to think seriously about what type of awareness you want to implement in your organization, and at different levels, at different times, and measuring what you are doing and seeing really results there, and not just giving a training that nobody cares, often boring, and that is not really working. And I see companies really involved in that and really trying to do that, but still not. It still is a challenge. And this is something that you can also link with the fact of acquiring some data minimization culture. So it's part of the awareness. If everybody has that mindset, it will come by himself, the fact that, well, we need to be mindful. Let's don't collect so much personal data if it's not really necessary. Another challenge, number 4, will be data breach protocol. Is something that I also say often, like a paper somewhere in a drawer, but that nobody really, when the moment comes, know exactly what has to happen there. So not only from our organizational perspective, it's a crisis moment, and you need to know exactly what you need to do. But of course, if you don't have the right overview what your data is and what you have, then it becomes almost impossible to find out if you really have a data breach. And another challenge that will be my number 5 is especially from the point of view of the GDPR is to really know which ones are your processors and if they are really processors and not just vendors. This is something organizations is still struggling with. And of course, just maybe a bit more related to security, but really do some vendor assessments because it's quite necessary. And that's still,
so I think
yes,
absolutely, the points that you've highlighted. So one thing which I can clearly see coming out is what type of data and the culture and the mindset. So moving on to Partha. So Partha,
yeah,
if you notice, we're talking about data as a whole. We've seen, and this is what we have also noticed within the organizations, they are moving from simply a check in the box activity to looking at embedding privacy as a whole in something which we are using the term as privacy plus programs instead of privacy. So what do you think are the organizations doing on that trajectory, and how can organizations, and some pointers maybe on how can they get latched onto their privacy plus program?
Thanks, Lilith. To my mind, I think privacy, besides what Loga and Isabel have rightly mentioned, to my mind, I think this is pretty much a governance issue, right? And unless the tone at the top, right, I really kind of really like it because it has to be really looked as not just merely a compliance issue, a tick off the box, right? It has to be approached from a perspective of governance, because only then can it not only be designed correctly, the architecture, whatever you call it, the process, people, the tools, but also the sustenance part of it. And I say it from my experience working in corporates, and even now getting an outside in perspective, I see that organizations, for organization right now, for depending on the maturity in which scale, at what stage they are, but privacy is kind of really table stakes right now, right? It's gone are the days when people will say, okay, tell me about GDPR. Everyone knows about it. They want something beyond, right? And therefore, this is seemingly going to see it, privacy as a topic, when you said privacy plus, is going to seemingly see that it's kind of really tethered or enmeshed with governance. And that governance issue in my mind is extremely critical, because it is not only a board level issue. The rationale of whether to really invest money and time in having a dedicated DPO, depending on the nature, the scale, the extent, the reach or the complexity of the business, but also to kind of really consider privacy as something which is integral, because we may not, we like it or not, but most of the time privacy could be seen as the debate could be like it is antithetical to innovation and all of that, right? That keeps on going on, right? But the question is, if it has to be enmeshed and made integral to business operation, it has to be seen as a governance issue. And to that extent, I find organizations are gravitating towards that model as part of the enterprise risk management model, and kind of really taking privacy as a matter of as a matter of their fiduciary responsibility, including the India's data privacy bill has also seen that this is a fiduciary responsibility. So I would equate that it's just like when organizations, handle investors' money, shareholders' money, it's a fiduciary relationship. It's a stewardship relationship. And in today's digital age, it's people's data, your and my data. And therefore, this is something which organizations have a duty of care, and they need to be fulfilling this job, not just as a matter of paper compliance, but as in letter and spirit, and not just as a black letter interpretation of it. So that's my viewpoint.
Thanks, Partha. If I may just add, the data governance as a critical aspect is something that cannot be emphasized enough. It is one of the core aspects of it, and the executive sponsorship, as you said. Just wanted to add a few points here. Is that we wanted to create privacy as not merely a process or not merely as a compliance, but as a culture. So privacy as a culture is what one should be aiming at, and every corner, every nook and corner of an organization, every person in an organization need to question: Am I doing the right thing in doing what I am doing? Is
Yeah.
privacy violated? Why should I share? What should I share? How much should I share? So privacy as a culture is what one should aim at. And again, towards this, uh, uh, again, three or four pillars, what we will say is that the privacy as a culture, and then demonstrability of the privacy natures. How do we sustain and also demonstrate to the stakeholders that it is being not merely complied to, but it is being lived as a culture? Those are the few points I just wanted to add, Partha.
Yeah, I think just to kind of really take that discussion a little forward, and Isabel, if you may just give me a couple of seconds. And I think, as you said, it has to be kind of made integral, right? What should the other party do? I think privacy practitioners also probably, and me included, kind of partner in crime to this, but of course, I think we also have a responsibility to kind of really be able to help businesses, right? Because I've seen in the urge or the excitement to kind of really get too many things correct, I think we also tend to forget that it is just not matter of legal compliance. Oh, this cannot be done. This is how it has to be done. We need to necessarily have an SCC in this manner only, right? And sometimes, I'm not saying it is not required, but sometimes this becomes pretty bureaucratic, right? Because you got the other compliances as well, right? And I think to that extent, if privacy has to survive, has to gain respect, it has to also see itself and transform itself from a matter of just regulatory compliance to a business enabling role. And that is something which we also talk about in privacy by design. But how do we do it? Because here we are dealing about human beings. Here we are dealing about managing people's egos, all said and done, and maybe different incentives, right? And, for a sales and a marketing person, they got to do and use that data. But then again, how do you ensure that that is being done in a manner where it's a win-win situation for everyone, right? And I think that's a kind of a tightrope walk, which privacy professionals themselves have to play for this to be sustainable and it to be a positive sum game, Loga.
Agreed.
Yeah, I think that's still a big challenge, especially. I mean, we talk here a lot about mindset, culture, but eventually, when it comes to automation, it becomes still a really big challenge how to translate the compliance legal side of privacy into really the technical implementation of process-wise implementation. And I think that besides the human side, it also requires I wouldn't call it bureaucracy, but just to implement really clear processes. Sometimes through some technology, we see it like in coding. If you implement some privacy and security code review, you are already helping a step forward. Besides awareness from the engineers, I mean, there's things that you can really do to improve certain technical processes. But yeah, I agree with both of you that the mindset is really the basis for everything in an organization. That's the first step.
Thanks, Isabel. I'm afraid Lalit is experiencing some difficulties. To move the conversation forward, I think apart from the pandemic and sort of the evolution that we've seen in privacy compliance, one of the biggest things to happen or come out of the last year is the Schrems 2 judgment and the changes that we're seeing globally in terms of data transfers. especially in the context of bilateral flows of data between countries. And I would love to get the panel's opinion on certain practical challenges and changes that we're seeing in the system. Loga, if we may start with you to give us the Indian industry perspective.
Sure, Anand. Thanks for that question. Shrums too, as definitely kept us busy last year and this year, and I think another 1 year or two going forward. The fundamental things, apart from the additional responsibilities on the importer also to deal with data subject rights. Earlier, it was a bit conditional, or under certain conditions, the importer or the processor needs to deal with it. The key thing, apart from the modular nature of the
Isabel, if we can get your opinion on the topic.
Yeah, it's something I've noticed. Well, Logan is true. Is back? Maybe not. If you want to continue.
Yes, please, Loga.
Yes.
No, I think it's still facing some challenges. You may go ahead.
Well, from my perspective, I see clients really struggling, especially when it comes to this transfer impact assessment that they need to perform. I used to say, I mean, if you look from their risk-based approach and starting to the first point from my comment of today, if you know where is your data, with the data is really important, and then start focusing there and continue with the assessment. I mean, maybe I've seen my clients overwhelmed with, oh my God, with all the applications that we have, the US, what do we do? I said, well, focus first. Define where are your high risks. If you just have maybe a third party that is just processing data that is not really in high risk, let's focus first on the ones that are really doing high risk, and then from there take it on. I must say that the guidance, also the last guidance release, I believe from the ADPS, it's also a bit confusing, especially for vendors that are also they need to comply with the GDPR and when they're outside the EU. So it's becoming a bit of a struggling for the organizations to to work on this. But eventually, what I see more the struggle at this moment, or at least since the past few months, is to know where to focus. Let's put it like that, and to decide what is really risk here. How can I define what is really a high risk? It's just with some documents enough from the third party, or do I need to do something more? Not sure if Partha would like to contribute also to this question.
Yep, sure. May I, Anand?
Yeah, please.
Yeah. So, and I think I completely agree with what Isabel had just mentioned. And I've had the opportunity to kind of really speak to clients in some of my earlier roles, and I think there are some tension points, specifically around. It's also a kind of a perception issue into my mind. It's geopolitical in nature. But I think first things first, one has to really understand the personal data, that we are talking about here, because as much as there could be some data which is accessed here, and then the probability that it could be subjected to surveillance because of law enforcement and all of that, that can happen in Europe as well. Just my personal views on that, right? The question is whether that piece of data which organization and a corporate or a body corporate would handle, would it ever be subjected to the FISA 702? Because it's not just about any data or every data. Yes, of course, there is a probability that even US service providers located outside United States, because of the long arm effect and because of the subsidiary effect, they could be subjected to the same subpoena request that they might get, or so on and so forth. But I think the question here is also to look at the practical side. What are the kind of requests that any corporate would have ever got in the past? What are their governance? And one has to also understand that not revealing that data is also illegal in a destination country. So how do we solve the problem? I think that has to be taken, again, a risk-based decision to look at the data, and if the data can be housed in Europe, but if it is to be viewed outside Europe, then of course the supplemental measures like encryption, anonymization, secure multi-party computation, all of that comes in. But again, a big but, still, we all know that anonymization is not foolproof. It could still kind of really take away, completely change the risk calculus. So I think we'll have to also live with some of the accepted risk, and that gets codified through our contracts, the new set of SCCs, as you talk about. And of course, it is the EDPB guidances have been less helpful to that extent. Even the earlier ones, the European Essential Guarantees one. Of course, all of that is there. But I think here, my own personal view is that what is expected out of corporates is that the data exporter in Europe has to do a mini adequacy for a destination country, which is actually the job of the European Commission. And this, in my view, and to the knowledge that I have been kind of really, and the kind of discussions that I've been part of, is something seen as kind of really too heavy, even on data exporters in Europe, because this is an adequacy test which goes far beyond the privacy remit, which means you're trying to really say, okay, what are the other legal jurisprudence? What are the warrant canaries that one could subject to, and can you do, and so on and so forth, right? And we also need to bear in mind that there are certain sovereignty that every state will enjoy. So I don't think it's a fair ask for a data controller in Europe or a data processor in Europe, whatever be the case, to kind of really do that adequacy. But that being said, this is a rule of the law, and I think this is something which we will have to really live with. But that means that organizations, again, will have that added responsibility not to take their ROPA exercises casually. They need to really do that well, because if they do that Article 30 ROPA exercise, then they probably are on the sound footing to really understand where is my data moving, as the data, right from the birth of the data to the death of the data. So I call that as probably from the cradle to the grave. And if all of that is being done, I don't think there is too much to kind of really worry about. Of course, there would be exemptions where even if the data has to be seen in clear text, then, of course, it is an option left to data exporters to take a call that keep the data there. But bear in mind, again, the same data could be subjected to the same surveillance measures in Europe itself.
So, thanks, Partha. Thanks, Isabel. I think an issue which is sort of interconnected to, you did sort of bring this up while you were talking about the transfer considerations. And this is a trend, I believe, which you will see emerging. A lot more sort of local laws have been talking about data localization or data residency measures. And while the conversation obviously is around privacy compliances and sort of looking at sort of revitalizing and restructuring your compliances, etc. What, how does sort of data localization impact your existing processes, and what sort of challenges exist in making those sort of changeovers to comply with these residency requirements? Isabel, if I may start with you.
Yeah, it's already like 1 year since I had that issue. Since now I'm working in different projects, pure privacy engineering, but yeah, I must say from a compliance perspective, it requires, of course, a lot of checks of what the third country is really requiring from you, what type of access they really might have to the data. So you need to also estimate what the risks could be also for your own like employees, for instance, or depends on who the data is, who the data subject is. So that requires that.
Is it better now?
Hi, you are back. So that will require also that type of exercise, and of course then you also have the from the security perspective, where you also need to make sure. I mean, also infrastructure. I mean, it really depends. It's like you are allowed to have only a backup there, or you really have to have really your server there, and you can have a backup in your headquarters or country. So it's a lot of questions you need to ask and decide if you really want to do that or not. So eventually, it's I would say, a risk-based approach that it really depends on the organization and needs and then use case scenario.
Hi, Lalit.
Not sure if Partha wants to add something on that.
So I think this is a tough one, but again, this is like, when people talk about data localization, I think emotions run high. But of course, leaving aside emotions, all I can say is that this is to be seen in the context of the data that we are talking about. Isabel, I'm sure you will not completely disagree, but to the extent that I'm aware of, there are localization laws beyond privacy, even in Europe, from a labor law perspective, and even like, personal data belonging to space and defense projects, which have to be localized. And I think, to my mind, this is an issue which has to be seen from a perspective of, okay, which data are we really referring to when it comes to localization, and what problem are we trying to solve through localization? And the issue with respect to, at least from an India perspective, if I have to probably safely say, and I think it's safe to assume that sometimes for law investigation or to kind of prevention of any crime or investigation of a law and order situation, data needs to be definitely be fetched. And if it is outside the borders of a country, we are all acutely aware as to how tedious and complicated the MLAT procedures are, as much as we might want to really fall back on them. So I think we need to have to really understand, if this data has to be housed within the borders, within the territorial borders of any nation, what objective are we trying to solve? State order, national security, or are we really trying to solve a problem of probably, just trying to kind of get it because this is also one of the incentives probably to generate more employment? And I think this is an issue which has to be, again, is multifaceted. It's just not, to my mind, is a privacy issue. It's geopolitical, economics involved. And that is also kind of accentuated by this Schrems II judgment, right? We already know in GDPR that sensitive data cannot be processed at all, provided the exemptions apply. And of course, those things continue. So I think to an extent of data localization, it helps. But just like as I say, right, privacy is like salt, and I really like it. You got to just apply that much of thing that is actually needed. Too much of it is bad for the health. Too much of privacy is bad. As much as I know privacy, I really, I'm passionate about this subject. But I think we need to really understand what problem are we really trying to solve. If there is a employee data, which is in the corporate ERP applications, or a Salesforce data, an email ID of just the salespeople, which is in Salesforce or maybe in any other application, and someone is able to have access to it, fair enough, because that's the business model, correct? Contrast that to someone's health information or maybe vaccination data, which really needs to be, from an employee perspective, being seen only from the local HR person, right? But given the construct and the model of various IT and ITS industries, and probably I can say that with a sense of responsibility as to what I have been privy to, the ask is always to ensure, if someone is doing a managed service, right, from India, right, for that matter, they need to really have access to the mobile number, because they need to probably then do the laptop repair. So if the admin guy doesn't have the address, the mobile number of that person sitting in Europe, how would on earth he or she even do the work? So we need to be probably having a very context-based, use-specific, and a risk-based scenario, and then take a call, and then have a very graded approach rather than just having a 0 or a 1 binary approach to data localization.
Thank you very much for both of your perspectives. I think it's a topic of debates on its own. probably a 6-hour discussion on just localization and its merits, demerits, and how does one go about complying with it. Thank you very much for sharing your perspective. One sort of one of the final sort of things that we wanted to cover as part of the discussion was uh, the conversation around having a comprehensive privacy law in India has been in the works for several years now, and now we've seen some recent development happening in terms of the JPC moving forward with its report and some possible conversations around tabling of the bill in the near future. As as distinguished members of the privacy community, I would like to sort of know your thoughts on not necessarily where the bill is going, but what sort of salient top 3 things that you would want the bill to take care of, or we should do well to make sure that India has a successful privacy framework.
Okay. I hope, is that question for me, Anand?
Anybody who wants to take it first, but let's say Partha. Yeah.
Yep. So I think first things first, where the credit is certainly due, the salient things probably it's a definitely a forward-looking bill in my view. In 70 years we've not had, but at least that attempt has been made after elaborate consultations. I think for 3 things in my mind that should be taken care of is the independence, the real independence of the data protection regulators, right? And that's where essentially one has to really bear in mind as to not right from their nomination to their ability to have functional independence at the same time an arm's length so that there is no conflict of interest. And I think that's extremely important. The second point in to my mind would be that we also, the bill, I think this bill to that extent has kind of mirrored GDPR to some extent, but it has its nuances, which is a good one. Is just not a cut, copy, paste model of the other countries because of our culture, of our the kind of the cultural variation. And I think to that extent we need to really think of a graded approach, right? So just like the Companies Act came in kind of in stages, right? We need to also really think about, do we really have now the capacity and the ability to kind of really roll it, even if it comes, into force? And that to some extent would be extremely required. And I think to that extent, the DPAs for that matter, because they are not just for enforcement, they also have to be enabled, and they will have to really come with a 360-degree view of doing enablement at various levels, right? And that to extent, I would rather say the ICO for that matter, just like they've done a wonderful job, right? Or the CNIL in France, right? So I think we need to, because we kind of really learning it, right? And the third point to my mind would be that we will have to really then also understand what would be the implications on the other statutes or regulations. So if there is a change in the Indian Evidence Act, what are the implications down below, right? And this has to be seen because even the IT Act for that matter is probably going to see some ramifications, hopefully. And we should not just see this in isolation, right? And therefore, even if to my understanding of GDPR, it never works in isolation. There is the understanding of the labor law and the employment law. And so in India, this particular bill says that, if I remember right, and I think it has kind of carved out, said for employment purposes, personal data can be used. But there needs to be very specific guidances because you just can't have a motherhood statement of for employment purposes, right? So I think these are some of the things, but it's exciting. And at the same time, we would also have to really look whether the DPA can have a central nodal function or whether it would have to really have some kind of a federal structure there.
Thanks, Partha.
If I may add, sorry, from the GDPR perspective and experience, I think would be, for what we have learned is that it's important that the privacy authorities really give proper guidance and clarity and help our organizations one way or the other. And of course, that they have enough resources to enforce the regulation. That's really important. Something we see it's not happening properly in Europe, and that doesn't motivate organizations to really implement privacy properly.
Yeah, I think that's a brilliant point. We are towards the end of our discussion. I think we can take one question from the audience if there is any.
I don't see, at least in the chat, I don't see questions. Just comments.
Yeah, no question, mostly comments. So I would sort of conclude the discussion in terms of what we have covered, and I think it's been a very brilliantly curated discussion. I will take 0 credits for stepping in and doing this. This was all put together by Lalit Kalra, partner EY, and in consultation with all of our distinguished panelists, Partha, Isabel, and Loga. Thank you very much for participating in the discussion and sharing your opinions. We try to put together these sessions, but it's actually the speakers who bring the real context and understanding and create a meaningful discussion for the audiences. Thank you. Thank you very much.
Thank you.